I'm sure some of you watching the channel are of a certain age and remember quite vividly where you were the first time you heard Led Zeppelin's classic song, Stairway to Heaven. I would also imagine that some of you, upon hearing the song, perhaps wondered whether the opening strains of the song was something that they might have heard before. Similarly, a few years later, in the late 80s and early 90s, in the beginning years of hip-hop, I'm sure that some of you felt, upon hearing Tone Loc's song Wild Thing, and especially a couple of years later, hearing Vanilla Ice's Ice Ice Baby, that those songs were very familiar. And jumping ahead a few years still later to 2009, I would imagine that upon seeing the great movie Avatar, that some of you believed that the imagery that James Cameron used in that film was again very, very familiar. This episode is all about intellectual property and copyright infringement. There are many well-known cases throughout the years of artists who have either unwittingly or deliberately stolen material from other artists in order to create a derivative piece of work. We're going to talk about a number of those in today's episode. I'll start out by saying that the information I'm going to share with you here is anecdotal, and it's based on my personal experience as being a rock and roll music listener for my entire adult life, and indeed going back to my teenage years. I am not a lawyer. I don't play one on YouTube, and I certainly don't play one on TV. My professional specialty is technology. I hold a master's degree in computer science, and I spent most of my career working in various capacities, either designing or developing software. So I know a fair amount about what software can do in creating and in some cases in replicating art. So in that regard, I think the opinions I'm going to share with you here are well informed. But please, from a legal perspective, don't take everything I say here at face value. If you are in a situation where you need to investigate or defend copyright of a piece of artistic work, by all means, please consult an attorney whose specialty is either technology, entertainment law, copyright law, or all three. Because the world is changing at such a rapid rate these days, where a combination of those skills is going to be necessary for you to get a total understanding of what is defensible in this area and what is not. That being said, I'm going to discuss three specific areas where copyright law applies to art as it pertains to the music business. One is music publishing, the protection of the songs that one has written. The second is protection of mechanical recordings, the specific recordings of songs by an artist for distribution either in physical form, for example, like on a vinyl album or on a CD, or in broadcast media, either over commercial radio, satellite radio, or over the internet, for example, via Spotify, or, for that matter, using YouTube as we are here. Last but not least is the artwork that's used to market a piece of music. For example, the cover art of an album or the picture sleeve of a single or extended play record. Of the three of these, the one that is most established is the concept of copyright protection for individual songs. As I make this video, song publishing has been around for well over the last 100 years. It goes back to the days of music halls, dance halls, and theaters, where the primary protection was being offered to sheet music that composers used to distribute their work. This would change over the course of the 1920s and 1930s with the advent of phonograph recording. Phonograph recording, of course, goes back earlier than that by some years, with Thomas Edison having devised the first phonographs before the turn of the 20th century. But by the 1920s, standardization was beginning to be applied to recording technology, with record producers standardizing on the 78 RPM speed for recordings at that time. By the 1930s, Victrolas and other similar phonographs were at a price point that was low enough for people to purchase them and install them in Depression-era homes. And at this point, the focus of publishing began to change to become less on sheet music and more on the recorded music that would be placed in the hands of consumers. The record business was an interesting one back in the 30s, 40s, and 50s. There were some very well-established and very Tony firms working in the business. The Decca Record Company in England, for example, goes back to the 1920s. The Columbia, Capitol EMI, and RCA Victor organizations in the United States go back to around that time frame as well. But there were also a lot of smaller and, to be frank, less reputable organizations out there making records. And it was not above some of these organizations to employ shady tactics in order to be able to get music into the hands of their customers. Some of these companies were affiliated with organized crime and did not have a whole lot of scruples when it came to violating the copyrights of others, particularly if the copyrights were in the hands of disadvantaged people. In particular, the so-called race records that were made in the 30s and 40s by black musicians were often violated by organized crime and even by the major labels in some cases, with the thinking that the artists, who in many cases came from the segregated American Deep South and may not have been very well educated, didn't know well enough that their music was copyrighted and didn't know that their music could be defended in court or that it was even worthy of defense. The unscrupulous people in the music business often took a two-pronged approach when it came to stealing the music of others. The first question that would often be asked was whether the music that they were looking to derive from or steal from was well known in its own right. If it was not, it was that much easier a target. Secondly, assuming that the music that they were stealing was copyrighted, the question that would be asked is, does the copyright holder have the resources to defend it? If the copyright was held by a large publishing organization or by a major record label, oftentimes the perpetrator wouldn't be bothered to try and steal from that source, because that source was financially well-heeled enough where they could defend their property. That would be less the case if a recording was made on a lesser label or by a small publishing organization, because it was felt that they would not have the financial resources available to defend. In such cases, the thief would often look to make a deal with the copyright holder to pay them a lowball price for their work and cut them out of future royalties on the song that they were looking to promote, or at the very best, to give them a co-author credit, basically devaluing the original, but making sure that they were able to maintain a piece of the action going forward. This sadly was a practice that continued for a rather long period of time, well into the 1960s and 1970s in particular. One of the more notorious artists that, at least on the surface, appeared to engage in this type of behavior was Led Zeppelin. under the auspices of their manager, Peter Grant. Peter Grant was notoriously unscrupulous and was always looking to get the very best deal for Led Zeppelin. While on the surface, this well looked to be a virtue, indeed the members of Led Zeppelin all viewed Peter Grant as being a fine manager from the standpoint of being able to get them the best deals for their shows and for their recordings during the band's existence. Peter Grant was well known in the business as being very difficult to work with and capable of negotiating tactics that in some cases were borderline criminal. Led Zeppelin were accused many times over the course of their career of copyright infringement. In fact, there is an entire Wikipedia page, a fairly lengthy one, that deals with this subject matter. And indeed, Peter Grant and Jimmy Page would make use of some of the more unscrupulous tactics in order for Led Zeppelin to be able to retain copyrights to songs where it was clear that Led Zeppelin were themselves not the authors of a given song. In the case of the song Dazed and Confused, for example, the original song, of course, was written by the American composer Jake Holmes and was recorded by Holmes for Capitol EMI Records on their Tower label. The Yardbirds saw Holmes in a performance in Greenwich Village performing the song and would rework the song with different lyrics and would perform that on that band's last tours. Led Zeppelin, of course, would continue to refine the song, recording it on their first album in late 1968, but crediting the song to Jimmy Page, with no mention of Jake Holmes. It would not be until many years later that Jake Holmes would ultimately be able to bring this matter to a head in a court of law. But by this time, Jimmy Page would make use of the tactics that I mentioned earlier, insofar as pointing out that Jake Holmes's version of Dazed and Confused, while predating that of Led Zeppelin, was not terribly significant in the marketplace. Holmes was ultimately fought off with a settlement, and Jimmy Page allowed, as part of the settlement, to retain authorship of Dazed and Confused, but with a clause added saying, written by Jimmy Page, inspired by Jake Holmes. Page also, of course, had a significant legal battle back in the 2015-2016 timeframe with members of the band Spirit over authorship of the song Stairway to Heaven. In these lawsuits, it was pointed out that the band Spirit, with whom Led Zeppelin toured in 1969 in their early days, that they had recorded in 1968 an instrumental called Taurus, written by Spirit's guitarist Randy Wolf, better known to the public as Randy California. Randy California had passed away in 1997. Mark Andes, who had been the bassist with Spirit, ultimately brought the lawsuit against Jimmy Page on Randy California's behalf. Here again, the court decided that Taurus was a rather insignificant recording and went so far in addition to say that the descending chromatic progression that began Stairway to Heaven, while very similar to that began the song Taurus, was a relatively common progression that was not copyrightable on its own. Numerous other cases of songs in the Led Zeppelin catalog can also be cited where Led Zeppelin would record a song that was originated by another artist, where ultimately, when that artist would bring lawsuit against Jimmy Page or Robert Plant, the settlement would be reached that Led Zeppelin would retain authorship, giving the original author a co-credit, again on the grounds that Led Zeppelin's recording of the song was the far more significant, that the only reason the original song would even be remembered was because of the work that Led Zeppelin had done to adapt it for their use. To be fair, Led Zeppelin were not the only bands that engaged in these tactics. Going well into the classic rock era, there are other situations where artists were accused of copyright infringement. George Harrison was famously accused in the early 1970s around his song My Sweet Lord and the fact that it was, in the words of the judge that presided on the case, unconsciously plagiarized by Harrison based on the tune of the Chiffons song He's So Fine, a song that I would have thought Harrison would have been well acquainted with, if not in his own, by virtue of the fact that his record producer at the time was Phil Spector, who was operating in that same time period as the Chiffons' original recording had been made. Interestingly, and perhaps somewhat ironically, there was, as I recall, also a lawsuit brought in the early 1970s by George Harrison against the members of the band Sweet regarding their song Fox on the Run, whose chorus bore something of a resemblance to that of Harrison's song What Is Life? Then there is Steve Miller, who has been involved in several copyright tussles stemming from songs from his most popular part of his catalog. In particular, the song The Joker is one that is significantly based on an earlier song called Lovey Dovey, which was co-written by the founder of Atlantic Records, Ahmet Ertegun. In this particular case, Miller chose the wrong person to steal from and ultimately needed to deal with that. The concept of protecting an artist's mechanical work, what is generally referred to as phonographic copyright, did not emerge until the early 1960s. In Europe in particular, in the early 60s, the concept of phonographic copyright was instituted to make sure that a song could not be illegally broadcast. The early and middle 1960s in England in particular were notorious as the years of pirate radio, and songs that were broadcast on, for example, Radio Caroline, were not subject to the broadcast royalties that needed to be paid to artists when they were broadcast on BBC and ITV affiliates. Ultimately, phonographic copyright would be instituted in North America as well, but that wouldn't be until several years later, until late 1971. In an earlier episode on this channel, I discussed at length a notorious incident where the application of phonographic copyright caused something of a rift between Frank Zappa and John Lennon and Yoko Ono around both artists' interests in wanting to make use of a live recording that the artist had created together in June of 1971, just before the phonographic copyright laws went into effect. The original concept of phonographic copyright in the States really had more to do with counterfeiting of records and bootlegging of live performances. In both cases, the record companies wanted to protect their own interests and make sure that only officially sanctioned recordings made by their artists could be distributed to the public. The scope of phonographic copyrights would change, however, starting in the middle and late 1980s with the advent of hip-hop music, where sampling would often be used to create the backing tracks for the raps that artists would capture for their recordings. One of the more notable examples from 1988 is Tone Loc's song Wild Thing, which uses a backing track that, while the tempo is changed slightly and there's some processing done to the track, is very clearly taken from the opening drum fill from Van Halen's song Jamie's Cryin'. Van Halen would ultimately bring this to court and would settle for a sum well into six figures with Tone Loc. A similar situation would take place in 1990 around Vanilla Ice's song Ice Ice Baby, where the bass line of that song very clearly replicates that of Under Pressure as recorded by David Bowie and Queen, where the bass line of Under Pressure, as performed by John Deacon, was do 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 do. Rob Van Winkle, Vanilla Ice, added one additional 16th note to the lick, do 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 do. And Van Winkle, because of that change, felt that that was substantial enough that he could not have copyright claimed against him. And to my knowledge, neither David Bowie nor Freddie Mercury sued Van Winkle over this. But as it happened, Van Winkle was signed to SBK Records, which was a subsidiary of EMI, which was David Bowie's label. And rather than have a situation emerge in the press where one of their leading stars would have an issue with the label, EMI took it upon themselves to change the songwriter credit on Ice Ice Baby to include David Bowie as a co-author, thus cutting into the songwriting royalty on Vanilla Ice's tune. An interesting anecdote on this for people who may not be familiar. When Ice Ice Baby was a big hit in the United States in 1990, Vanilla Ice was signed to appear on the American late-night program Saturday Night Live. He performed Ice Ice Baby on the program, and the show went to commercial break to return to their normal current events segment called Weekend Update. Dennis Miller, who would deliver the Weekend Update segment on Saturday Night Live every week in this time frame, would typically open Weekend Update with a quotation from a classic rock song. And sure enough, on this particular episode, the song that Miller used to open the segment was Under Pressure, the original version by David Bowie and Queen. After playing the first several bars of the song, Miller broke in and stated, "Oh, Bowie, what a classic song that is. I bet someone could record that today and it would be a hit." One last point to make as far as mechanical copyrights are concerned is that technology makes it very, very easy to enforce such copyrights in this day and age. Those of you who are creators on YouTube, as I am, know from first-hand experience that when you upload a video to YouTube, one of the pieces of processing that is done before the video can go live is to review it for copyrightable material. YouTube has a huge database of music provided by both major and smaller labels that it reviews to determine if any of the content that is being presented in the new video might possibly have a copyright claim against it. It's one of the reasons why I very, very infrequently include music clips in my videos. It's not worth the headache. Finally, I will talk a little bit about artwork of a conventional style, namely the cover art and other materials that might be associated for distribution with a piece of music. Generally speaking, going back to the beginnings of the classic rock era, these types of materials were not really protected to anywhere near the same degree as the music itself was. In many cases, back in the late 60s and even extending into the early and middle 70s, the cover art for an album was often treated as a work for hire, where the artist was paid a flat fee for the work, at which point it became the property of either the artist or the record company or both, and with them at that point being allowed to use the artwork as they saw fit. We've covered a discussion in a previous episode on this channel around Jethro Tull's album Aqualung, where the cover art was purchased by Chrysalis Records from the artist Burton Silverman for a flat fee, and Silverman going on to regret that deal by virtue of the fact that the artwork was used by the artist in particular in ways that he had never envisioned, like in merchandising, for example. Over the course of time, artists would become much more savvy in terms of retaining their copyrights. But even owning the copyrights for your work may not protect you from infringement, as Roger Dean found out several years ago in the case of the movie Avatar. Most viewers who have seen Avatar and its depictions of the world of Pandora by James Cameron have very quickly made the connection between those visuals and the visuals from Roger Dean on, in particular, his album covers for Yes and for Asia. Roger Dean obviously made the connection as well. He sued James Cameron for $50 million, claiming that the depiction of Pandora stole no less than 14 different elements from his various album covers created over the years. In this case, it couldn't be argued that the original work by Roger Dean was not significant. Yes's albums Close to the Edge, Fragile, Tales from Topographic Oceans were all platinum sellers. Asia's first album, with artwork by Dean, was a diamond seller, over 10 million sold. Ultimately, however, an American judge in the courts in New York threw Roger Dean's lawsuit out using a different theory, saying that first off, Dean's work was generic, representing his views of fantasy worlds, and that those themes were often used in depictions on album covers back in the late 1960s and early 1970s. The judge then went one step further, saying that there was a unique element that was presented in the depictions of Pandora in Avatar, specifically that since they were animated and using 3D processing technology, that they had taken this to a technical level that Roger Dean had never, and that they therefore were, with Avatar, creating unique and new work, with Dean's lawsuit being dismissed as a result. As a technologist, I see tremendous irony in that. Certainly in the late 2000s time frame, some 18 years or so ago, as I make this video, the technology to create the 3D effects in Avatar would have been very new and probably very difficult to manipulate. Looking at it, however, through the lens of the current day, with the AI technology that is out there now on any host of public websites, I can create 3D imagery in an afternoon. As I make this video, there's a sequel to Avatar that will soon be hitting distribution. I almost wonder if it's time for Roger Dean to consider reintroducing yet a new lawsuit in order to get the credit for at least what I consider to be rightfully his. In interviews around the subject, James Cameron has gone so far as to say that, yeah, there probably was some influence from Roger Dean in his album covers back in my pot-smoking days, as he said, probably making a little bit too much light of the situation, at least in my opinion. Anyway, those are my thoughts around copyright law as pertaining to the music business. Curious to hear what you have to say, as always. There are probably many cases of infringement that are worthy of discussion that I haven't brought up here. And of course, you can bring those to my attention in the comments. There may be some things I've said that you disagree with. I know there are, in particular, quite a few people out there who believe that the Spirit lawsuit against Jimmy Page over Stairway to Heaven was without merit. And you're certainly welcome to your opinions there. I personally don't agree. I think by virtue of Spirit and Led Zeppelin touring together, that there was more than a passing familiarity on Jimmy Page's part with Randy California's work. But again, feel free to share your opinions on the matter, and we'll be happy to pursue conversation. Anyways, thank you for watching as always. We will be back here soon. You take very good care. Bye-bye.